In Unit 7, we're going to cover advertising regulations. I'm going to show you how to legally export vehicles to other countries. We're going to talk about sales to minors, off-site sales, emissions, and out-of-state VIN inspections. So let's go ahead and get started with Georgia's dealer advertising law. You know, as you already probably realize, a very important component of the operation of any Georgia dealership can be advertising. And, you know, there is a reason that every other ad that we hear on the radio and see on TV is a dealer ad, because advertising in our industry can be very effective. So I want to cover some of the state's advertising regulations with you in an attempt to help you maintain compliance. The Georgia Fair Business Practices Act declares that unfair or deceptive acts or practices in the conduct of consumer transactions are unlawful. The Georgia Fair Business Practices Act states that its purpose is to basically protect consumers and legitimate business enterprises from these practices. The Georgia Fair Business Practices Act includes examples of practices which are deemed to be unlawful. And this is due to the fact that for many consumers, the purchase or lease of an automobile constitutes a major financial obligation, second only to that of the purchase of a home. For that reason, the state wants to ensure that your customers are given adequate, accurate information in advertisements prior to purchasing a vehicle from you, and that the sales tactics dealers use are fair. The Georgia Fair Business Practices Act derives policies directly from the Federal Trade Commission advertising regulations. So you are following these state advertising guidelines. You should also be compliant with federal advertising guidelines as well, because the state advertising guidelines were developed based on the FTC guidelines that came out of Washington. The following advertisement regulations apply whether you're advertising in print, radio, television, display, all forms of internet advertising, and any other type of advertising medium. They are based on Federal Trade Commission advertising standards and are applicable to every single dealer in the state. First, I want to cover some advertising methods that have been determined deceptive, and you never want to run deceptive advertising. Running deceptive ads could lead to an investigation of your dealership by the state, and that's something that you always want to avoid. Like I say, we always want to kind of fly under the radar. We don't want the state hearing our dealership's name because of non-compliance issues. Deceptive advertising is never allowed under any circumstances. And here are several examples of deceptive advertising. The use of inaccurate photographs when advertising specific automobiles is deceptive. So you can't show that beautiful photograph of that, that Cadillac Escalade, and then all of a sudden when someone comes to the dealership to take a look at it, it's a big dented up piece of junk. You can't do that. We can never use inaccurate photographs. You know, the use of any unexplained abbreviation is confusing and not readily understood by the general public is deceptive as well, such as, printing an ad with WAC instead of with approved credit. There's probably a lot of persons that don't understand WAC stands for with approved credit. So we can never run abbreviations that are confusing or not readily understood by the general public. The use of any print or type size so small as to be not easily readable. The use of terms specially selected, valued customer, or similar terms is deceptive if the customer has not been specifically targeted with that advertisement, such as with maybe a direct postcard mail piece. It is deceptive to use one or more asterisks in which disclaimers confuse or contradict the message of an original advertisement. The use of audio disclaimers that are confusing or unclear due to lower volume, the speed of the speaker, different voices, background noises, or music. So you can never use an audio disclaimer on a radio ad or even a television ad that cannot be readily heard and understood. Falsely implying that a dealer can sell vehicles at lower prices than other dealers because of the size of their inventory or sales volume is unfair and deceptive. So you can never say that, we've got the lowest prices because we have the lowest selection. That's against the law. We can never use terms such as that. Also, the terms such as select models, select vehicles, a special selection, and other terms of similar nature should only be used if the advertisement specifies which models or vehicles are actually included in that offer. Also, using repossession sale, seized vehicles, or other similar terms to induce a belief that the vehicles were obtained through repossession or seizure and sold at lower prices is unfair and deceptive unless it is in fact true. It's deceptive for a dealer to offer a vehicle at a specific price and fail to make that vehicle available for sale. I want to repeat that one. That's a very important one we need to know about. It is deceptive for a dealer to offer a vehicle at a specific price and fail to make that vehicle available for sale. If an advertised vehicle is not in stock, the advertisement must specify that that vehicle is not in stock and may have to be ordered. An advertisement that fails to disclose the duration of a limited time offer, including any type of manufacturer's rebate sales or special promotions, is unfair and deceptive. So everyone, when you are running an advertisement for a sale, the law requires that you have the beginning date of the sale and the end date of the sale in that advertisement. That way there's never going to be any type of confusion about when those sales prices are actually in effect. The use of lowest prices, guaranteed lowest prices, prices lower than anyone else's, or other similar terms is unfair and deceptive because those claims usually cannot be substantiated. Comparing the offering price to the dealer's cost or actual cost or similar terms is inherently deceptive due to the difficulty in determining the dealer's net cost. So we can't use dealer's cost, actual cost, or similar terms because we just can't prove really what the dealer's net cost was. That's very difficult to determine. The use of the term certified in connection with the sale or lease of used motor vehicles is deceptive unless the manufacturer has an established inspection program for pre-owned vehicles backed by the manufacturer's warranty, and the vehicle has passed such an inspection according to this manufacturer's exact standards, which is very difficult to do. So we normally aren't going to be running, a certified ad for motor vehicles that we've sold according to manufacturing standards. No money down advertising. While using terms such as no money down and no down payment are allowed under the Federal Truth in Lending Act, they should only be used in those instances in which your customers may take delivery of vehicles with absolutely no out-of-pocket expenses. If the customer is required to pay any money whatsoever to the dealer or the lien holder, then such claims may not be used. So you cannot use no money down, no down payment if the customer is required to pay any sort of out-of-pocket expenses. Your customer may be required to pay fees such as tax, tag, and title, and still be considered to have purchased a vehicle for no money down, so long as those amounts are actually collected by or on behalf of the state. Special finance rates. Special finance rates available by means of dealer buy-downs should specifically disclose that the dealer participation may affect the purchase price. Wholesale prices. It is illegal for any dealer, by use of the word wholesale or similar words, to represent that the dealer is a wholesaler or selling goods at wholesale prices, unless it is actually selling a vehicle wholesale to another dealer and not selling the vehicle to a consumer. I want to repeat that again. Okay, we can never use the word wholesale prices or similar words to represent that you're selling vehicles to the public wholesale. You can maybe run an ad in a motor vehicle trade magazine to other dealers or something like that if you're using the word wholesale. But when you're advertising to the general public, we cannot ever advertise wholesale prices or give any inclination whatsoever that we are selling vehicles at wholesale prices to the general public. A violation of this statute is a misdemeanor, by the way. So you really want to watch your wording in your ad and never use the word wholesale or similar terms, because that is a violation of the Fair Business Practices Act under state law. Fleet prices. Using the term fleet in advertising directed to the public has a tendency and capacity to mislead. And, this is due to the fact that manufacturers sell vehicles to rental car firms, major corporations, and government agencies at true fleet prices, which are often less than the prices which dealerships sell vehicles to consumers. So actual fleet prices are based on large volume of vehicles sold, normally to government entities and things like that, and they're not available on a single vehicle purchase. So since actual fleet prices are not available to the general public, advertisements that are given to consumers using this term will be considered misleading and deceptive. So you don't ever want to use the word fleet pricing, because usually that's going to only apply to one vehicle, which would be misleading and deceptive and a violation of the state law. Words such as inventory liquidation, emergency, forced to sell, prices slashed, inventory closeout, or similar terms should not be used unless the price has been permanently reduced by a significant amount from the actual price and will not be increased at a later date. Going out of sale businesses. It's unlawful to conduct a going out of sale business or other forms of distressed sale for more than 90 days. And after that 90-day limit, it shall be determined unfair and deceptive if you are still in business. So, I hope this is an ad that you never have to run. I certainly don't want you to ever go out of business. But if you are ever going to run, say, for example, a going out of business sale, then you will, in fact, have to go out of business. But I don't know why this law does not apply to the furniture stores. How many times have you seen that furniture store that has persons waving a sign around on that busy intersection saying they're closing next week, and then 2 months later they're running that same sale? So don't ever run a going out of business sale unless you are in fact going to close your business. And like I said, I hope this is a sale that you never ever have to run. I've seen cases where dealers have actually ran going out of business sales every 2 to 3 months. And obviously that is a violation not only of state law, but it's also a violation of federal advertising law. Let's talk about free items. You cannot advertise free items unless they are free to everyone, regardless if they are a customer. You cannot say, for example, run a radio ad advertising free hot dogs. And when someone comes in asking for a free hot dog and you tell them they have to take a test drive in order to get the hot dog, then you're obviously in violation of the law. Free items that you advertise must be free for everyone, regardless if they are a customer. You can never require someone to do something for the free item. Guaranteed trade-ins. Let's talk about guaranteed trade-in amounts. Dealers may not use terms such as guaranteed trade-in, minimum trade-in, push, pull, drag, push it, pull it, tow it, or similar terms. How many times have we heard this? And I think as we go through this advertising law, you're going to realize there are a lot of dealers out there that are running illegal ads and probably don't even know it. So that's one reason, obviously, we're taking our continuing education is hopefully to let you be aware of these deceptive advertising practices. Dealerships may not advertise a guaranteed minimum trade-in amount because the general public believes that no matter the fair market value of the vehicle they bring in as a trade, they will receive the guaranteed amount, and this guaranteed amount will be subtracted from the purchase price of the vehicle they're purchasing. This is not the case because the lowest price at which a dealer is prepared to sell the vehicle is increased to compensate the dealership for the loss it will incur for accepting a trade-in whose value is less than the offered guaranteed minimum. So don't ever advertise guaranteed trade-ins. Also want to talk to you a little bit here about the absorption of sales tax. Georgia law generally prohibits anyone engaged in retail sales, such as automobile dealers, from advertising that the dealer will absorb all or part of the sales tax or relieve the purchaser of the payment of that tax. The law does provide, however, an exception for dealers who want to make such a claim, so as long as they abide by 2 conditions. First, the retailer must include in the advertisement a statement that any portion of the tax not paid by the purchaser will be remitted by the retailer, such as the dealer. Second, the dealer must give the purchaser written evidence showing the retailer will be liable for and pay the tax the consumer would otherwise have been obligated to pay. So, if this is something you're doing, you certainly want to be doing this with legal advice to make sure that you have that you are following all the standard guidelines. But remember, Georgia law generally prohibits anyone, such as dealers, from absorbing the dealer's all or part of that sales tax. So if that is something you want to do, like I said, I would certainly recommend, if you are doing a program like that, get some legal advice just to make sure that you do have the correct documentation. Don't wing it. We don't ever want to do anything, especially any type of advertising policy or practices, without some good legal advice. So just keep that in mind. A dealer who advertises they will cover or absorb a consumer sales tax without complying with these 2 requirements is in violation of the law, as well as the Fair Business Practices Act. So, if you run illegal ads, even unintentionally, you can be found guilty of a misdemeanor. So you want to make sure you're following these advertising guidelines. Make sure and review these videos after the course here at georgiadealer.com. Or be sure to consult with an attorney. If you ever consider running ads, the state you will absorb your customer sales tax. I want to talk about credit approval claims. Advertising statements such as pre-approved may only be used if the person to whom the offer is made has an unqualified right to take advantage of it. And there can be no conditions that a consumer must meet in order to take advantage of the offer, because pre-approval implies that a potential purchaser's credit status has already been evaluated and found to be acceptable. Furthermore, offers of pre-approval, when used in conjunction with an amount up to, will be considered deceptive. I want to repeat that one more time. Offers of pre-approval, when used in conjunction with an amount up to, are considered deceptive and can lead to an investigation of your dealership by the state. And like I said, we want to fly under the radar. It is, however, permissible to state that a consumer is pre-approved for a minimum amount. Let's talk about discounts on used motor vehicles. It is deceptive to compare used vehicle prices with the original manufacturer's suggested retail price for vehicles, because there is no manufacturer suggested retail price for used vehicles. I want to repeat that. It is deceptive to compare used vehicle prices with the original manufacturer's suggested retail price for the vehicles, because there is no manufacturer's suggested retail price for used vehicles. Manufacturer's suggested retail price is only for brand new vehicles that are being sold by franchisors. Dealers may not state that customers can save a specific percentage off the MSRP, such as up to 50% off of MSRP. We can't run ads like that. They are against the law. So never advertise that we're running a percentage off of the MSRP. That is against the law. False price comparisons on used vehicles cannot be used as well. So for example, running an ad that states was $12,995, now only $98.99. This ad concept should never be used. Okay, so do please keep that in mind. They do not want you running price comparisons. Lifetime warranties. If a dealer advertises a lifetime warranty to describe the duration of a warranty or guarantee, then the advertisement must disclose with such clarity and prominence as will be noticed and understood by prospective customers how long the life actually is. So it's important to note that dealers that advertise lifetime warranties on vehicles and then later go out of business may not be relieved of the responsibility to honor those warranties. So please do keep that in mind. Be very cautious whenever running lifetime warranties, and definitely if that's something that you put in your advertising, you certainly want to do that under legal guidance. Money back guarantees. A dealer in the state may use the term money back guarantee, satisfaction guarantee, risk-free trial, or similar representations only if the dealer refunds the full purchase price of the vehicle sold at the buyer's request and clearly and conspicuously discloses any condition or limitations in that advertising. Price matching offers. The use of terms such as guaranteed lowest prices, or will beat any deal, will match your best offer, we won't be undersold, or any other similar terms must include clear and conspicuous disclosure of all conditions or limitations of those offer. Will beat any advertised price is an acceptable offer. The consumer may be required to produce a competing dealer's advertisement in order to substantiate a claim of that offer, however. Such offers shall not require the presentation of any evidence which places an unreasonable burden on the consumer or even on the competing dealer. So examples of unfair requirements would include, but are not limited to, requiring the customer to produce a signed buyer's order or contract for that price match, requiring that the customer pay a deposit to the competing dealer. You can't make them, pay that deposit to the competing dealer just to get the price match. You can never require a competing dealer to sell the vehicle to the advertising dealer. So keep that in mind. Or require the production of a written offer from the competing dealer. So, they make it pretty complicated when you say you're going to match a price. So make sure you're following these guidelines. to ensure your compliance. Spot delivery. I want to spend a little time on this one. It is deceptive for a dealership moving forward on the sale of a vehicle when approval of financing on the vehicle is not final. I want to repeat that, and we're going to spend some time on this here. It is deceptive for a dealership moving forward on the sale of a vehicle when approval of the financing on the vehicle is not final. If the sale of a vehicle is dependent on final approval of financing by a lender or lessor, then the dealer must keep the title and possession of any vehicle traded by a consumer as part of the transaction until financing has actually been approved. So just remember that. If a sale of a vehicle is dependent on final approval of financing by the lender, then the dealer must keep the title and possession of vehicles that were taken on trade. A problem that has been seen in this scenario is when a dealer takes a trade-in, helps the customer apply for a loan, and completes the deal before final financing is approved, then the dealer sells the trade-in, and then the customer does not receive final approval of the loan. The customer has to bring their car back, and the dealer no longer has the trade-in. So let's keep that in mind. If financing cannot be secured and the customer chooses not to apply for a loan for the purchase of the vehicle, then the dealer is required under state and federal law to immediately return to the customer any traded vehicle or any down payments previously submitted by the customer as part of that transaction. So please keep that in mind. Spot delivery rules are very strict, okay? Remember, these advertising regulations apply not only to print advertising, such as your local newspaper. These advertising regulations are going to apply to radio advertising, television advertising, all types of internet advertising. If you're selling vehicles on Facebook Market, Craigslist, or something like that, or even your own dealership, all these same rules, your own dealership website, all these same rules will apply. I want you to be aware, if you have any questions regarding dealer advertising regulations, you can easily contact the Georgia Department of Law Consumer Protection Unit, and that's going to be at 2 Martin Luther King Jr. Drive, Suite 356, East Tower, Atlanta, 30334. And that phone number for the Department of Law's Consumer Protection Unit is going to be 404-656-3790. Once again, 404-656-3790. And I want you to be aware, if you think about it, we've probably all heard, read, or seen some illegal ads. And I've heard ads that will major dealers will run, and they'll say something like, free hot dogs for the first 50 customers on a radio ad. Well, the law says free items are free for everyone, regardless if they're a customer. So, you will hear illegal ads that other dealers may be running on the radio or even running on television or a newspaper. Make sure we never even copy those advertising concepts. Let's maintain compliance and do exactly what we talk about in this course, and that will help you maintain advertising compliance. And if you've never advertised, if you do advertise in this business, you will certainly see an increase of foot traffic. So if you're going to advertise, make sure that you are maintaining compliance. Okay. So I want to talk to you and let you be aware that the legal age to sign legally binding contracts, such as all the documentation required in a motor vehicle transaction, is 18. I want to repeat that. The age to sign legally binding contracts, such as all the documentation required in a motor vehicle transaction, is 18. So your customer must be 18 years of age to purchase a vehicle from you. And, I want you to be aware, in a worst case scenario, let's say you sold a motorcycle to a 17-year-old, and let's say he signs all the paperwork and pays you with $5,000 in cash. This 17-year-old could drive that motorcycle right down the street, total it out, then drag the damaged motorcycle back to your dealership, and you would have to take the damaged motorcycle back and give $5,000 back to the customer because you completed a sale with someone that was not old enough to sign any legally binding contracts, which would basically give you no legal or financial recourse during this specific transaction. You must always ensure that anyone purchasing a vehicle from you is at least 18 years of age, unless they're defined as what we call an emancipated minor. An emancipated minor, also called, sometimes they call it a divorce from parents minor, refers to a court process through which a minor can become legally recognized as an independent adult. An emancipated minor is defined as any person who has entered into a valid marriage, is on active duty with any of the U.S. Armed Services Forces branches, or has received a declaration of emancipation from the Children's Court of the district in which he or she resides. A contract to purchase a vehicle signed by anyone younger than 18 years of age, other than an emancipated minor, is invalid and may be voided. So, if you sold a vehicle to a minor, they could release themselves from that sales contract, return the vehicle, and recover the entire vehicle purchase price, even though the vehicle's been used, wrecked, or deteriorated in value. So always make sure that your customers are at least 18 years of old. So unless your customer is an emancipated minor, you certainly want to make sure that they are at least 18 years of age. In fact, state law does allow you, if you suspect a person buying a vehicle from you is not 18, you can ask for your photograph for their ID. And I always want to recommend, as well, as we talked about a little bit earlier, whenever you have a person wanting to take a test drive, well, we always want to get a copy of their insurance and their photograph ID. So you'll be able to see their photograph ID just by having the policy that someone must show a driver's license and proof of insurance to drive any vehicle. So that right there, just by having that copy of that person that's test driving that vehicle, make sure and take a look at their birth date and make sure, no matter what their 18 years of age, if they do decide to move forward on that purchase, then you're going to know that they are old enough to sign the legally binding contracts that are involved in a motor vehicle transactions. I want to briefly cover emissions inspections. And, according to Georgia law, all sellers of gasoline-powered cars and light-duty trucks that weigh 8,500 pounds or less, located within the 13-county testing area, regardless if they are a private party, dealership, or even an auctioneer, must sell a vehicle with a current valid passing Georgia Vehicles Emissions Inspection Report, which is known as your VIR. If the buyer is going to register the vehicle in one of the 13 metro Atlanta counties, and the counties that we're talking about are going to be the counties of Cherokee, Clayton, Cobb, Coweta, DeKalb, Douglas, Fayette, Forsyth, Fulton, Gwinnett, Henry, Balding, or Rockdale. I want to read those one more time. The counties of Cherokee, Clayton, Cobb, Coweta, DeKalb, Douglas, Fayette, Forsyth, Fulton, Gwinnett, Henry, Paulding, or Rockdale. So if your buyer is registering the vehicle in one of these counties, then you must provide a current VIR. If your buyer is registering the vehicle in one of these counties, you must provide a current VIR. Most vehicles that are older than 3 years and less than 25 years old must be tested when registering in those counties. So always keep that in mind. If you ever need to check a vehicle's emissions inspection, obviously you can just go to cleanairforce.com. Once again, that's www.cleanairforce.com, and click on that box there that says most recent test results. Very easy to do. And then you can easily enter your VIN in the box, and you see here the current VIR. So I'm sure you've probably already been doing this, but I just want to give you a really quick reminder on your VIR requirements. Here's a list of emissions exemptions vehicles, okay? So these vehicles are going to be exempt from the VIR, and those are going to be vehicles that weigh more than 8,500 pounds, diesel, propane-driven vehicles, 3 most recent model years, so those are going to be the 3 newest years, okay? Antique collector vehicles, vehicles that are more than 25 years old, motorcycles, RVs, and motorhomes are also going to be exempt from that VIR. But I want you to be aware, if you ever have any specific questions regarding emissions, then you can easily contact the Clean Air Force. Once again, that website is www.cleanairforce.com. You can send them an email at info@cleanairforce.com. And here's their 800 number. It's 800-449-2471. Once again, that's 800-449-2471. Transfer and title of license plates from another state or even another country. When you purchase a vehicle to resell and the vehicle has a title from another state or another country, the new titles can be obtained from your county tag office with the following information. You're going to need a completed and signed MV-1 title tag application. And by the way, we have links to all these at georgiadealer.com. Just scroll down there to the bottom and click on Georgia Dealer Forms. You'll also need the original valid title issued in your name or properly assigned to you. Out-of-state, country valid registration certificates if applicable. You're going to have a completed and signed Form T-22B, Certificate of Inspection, Georgia liability insurance reported by your insurance company and on record with the department. The emissions inspection certificate if applicable. English translation of any documents that are not printed in English language. That would be if for some reason maybe you're importing vehicles from another country. Obviously that's going to be a process that's going to have to go through United States Customs, and they will be able to walk you through that. It's always a little easier to export a vehicle than it is to import a vehicle. But here you see that Form T-22B. This is your certification of inspection that would be completed by law enforcement if you need that. So, you'll be able to contact those easily. That's the Motor Vehicle Division inspectors through the Department of Revenue. And like I said just a moment ago, as a reminder, you can always download all the forms in your dealer training course at georgiadealer.com. Just, scroll right down to there at the bottom and click on Georgia Dealer Forms to download all the forms that you need. All the forms that we have used in the course are on that website, and you check back. We're always going to be updating it as well with new forms, and we always try and have a link to the most current forms, because lots of times the state, they might have a form that came out this year and all of a sudden they've got a brand new form with additional information next year. So we'll always try and keep links to the most updated forms at georgiadealer.com. Now we have completed Unit 7, and I want to remind you, you can always review any of these training videos that you completed at georgiadealer.com. Once again, that's georgiadealer.com. Click on the dealer video link at the top of the page. Right now you cannot fast forward through this. If you're taking the training through the learning management system, you cannot fast forward through this, any content. But after you finish the training, like I said, you could just easily jump right there on the website. That was Unit 7, a pretty extensive unit that we had right there. And at that time on the website, you can easily fast forward or rewind to the content that you need. So please do keep that in mind. And now let's go ahead and move on to Unit number 8.